Grateful, my lord. May it please your lordships. My lord, I had stopped yesterday at paragraph 269 of my lord Vijay Madan Lal Chaudhary. So may I kindly invite your lordship's attention to that. That separate copy, which was given by Miss Atrishi.
Yes.
Para 269, we were. Now, my lord, this is important for this reason that, my lord, reason to believe is linked to section 3. My distinguished friend argues that the learned judge takes a view and is trying to read into reason to believe many things. That's not true, because section 3 is the real section. It's like a charging section in a taxing statute. Section 3 is the charge of criminality and the power or jurisdiction to enter upon an inquiry. So please see, my lord, para 269, last sentence. Para 269, last sentence where we had stopped yesterday. Thus, offense otherwise has nothing to do with the criminal activity relating to a scheduled offense, except the proceeds of crime derived or obtained as a result of that crime. Then your lordships may see paragraph 271 at the foot. Para 271, my lords. As mentioned earlier, the rudimentary understanding of money laundering. Now see, this is very interesting. Rudimentary understanding of money laundering is that there are 3 generally accepted stages to laundering. They are placement, which is to move the funds from direct association of the crime. Now, my lord, that's not the case here. There is no funds which have been moved from the crime to anybody else. B, layering, which is disguising the trail to foil pursuit. And C, integration, which is to make money available to the criminal from which seem to be legitimate sources. Then para 272. It is common experience world over that money laundering can be a threat to good functioning of a financial system. Para 272, my lord.
One.
But as I said, section 3's debate starts at page 263, para 263 onwards. But we are reading para 269, 271, 272.
Yes.
My lord, the Chief Justice has, my lord, para 272 now.
Yes.
It is
common.
Yes, ma'am.
Yes.
It is common experience world over that money laundering can be a threat to good functioning of a financial system. However, it is also most suitable mode of criminals in such money. It is the means of livelihood of drug dealers, terrorists, white-collar criminals, and so on. Pause here, my lord. Just pause here for a moment. Kindly, my lord, appreciate this. Here is a case where government is giving the plots to the landholder. Where is the question of money laundering here? The government, Lord, it may be a wrong decision. It may be a decision which is against public interest. But there is no money laundering here. There is no money which is derived from criminal activity. Therefore, there is no proceeds of crime, which is condition precedent. The plots are given in lieu of land acquired without authority of law, because no compensation was paid, admittedly. So the plots were given, and that too, my lords, plots were given to Srimati Parvati. I, as a commissioner, have nothing to do with it, my lord. Why am I being dragged into this controversy? What I have done as a commissioner is what the rules provided, what the resolution of Muda provided. I was not a party to them.
Only to understand, which may have nothing to do with this matter. The proceeds of crime is not limited to money.
No, not necessarily. Your lordships are right.
Right.
That those may have been converted. Your lordships are right.
No, even the definition and the sections which speaks of proceeds of crime doesn't refer to money part only.
No, I'm not saying that for a moment. I'm not
Yes.
saying. Your lordships are absolutely right. My lord,
Yes.
it can be in any form. It
Yes.
can be in the form of, my lord, property. It can be form, but it must be proceeds of crime.
That's
What
right.
my emphasis is, my lord, that there is no proceeds of crime here.
There you are right. Yes.
Here the plots. Let us assume plots are money. Let us assume. But those plots have not been derived from a crime. Those plots were given by government as part of a statutory exercise, a policy decision of Muda, in lieu of land which is taken over by government without paying compensation. Which, my lord, your lordship's court has upheld again and again. I will read, my lord, Justice Nagaratna's, my lord, judgment as ladyship was in Karnataka High Court in the division bench. There, my lord, the division bench sustained 15 plots allotment. And, my lord, said single judge was absolutely justified in giving the plots. Another division bench headed by Justice Ravi Math, as lordship's then was, also said, yes, plots have to be given. And a third division bench, my lord, took that view, against which SLP has been dismissed by Supreme Court. So, my lord, this allotment of plots is part of government's policy. It's a statutory exercise. It's a policy exercise. It has nothing to do with a crime. And it is irrespective of, my lord, political party. Janata Dal government has given, Congress government has given, BJP government has given. So is the ED going to reopen all those millions of cases and say that these are all proceeds of crime, therefore we will go after innocent citizens? That is the question before your lordships today.
Yes.
So, my lord, para 272. Tainted money breeds discontent in any society and in turn leads to more crime and civil unrest. Thus, the onus on government and the people to identify and seize such money is heavy. If there are proactive steps towards such a cause, we cannot but facilitate good steps. So, my lord, why did the court justify it, this law? Because to fight, my lord, drug dealers, terrorists, and white-collar criminals. My lord, an innocent action by government is not to be treated as a, my lord, crime. However wrong it may be, however unpalatable it may be. Somebody just after 15 years files a, my lord, complaint to Lokayukt and ED swoops into action and says thousands of plot holders, now you come and we are summoning you under 50, make statement. No, my lord, that's not the power. That's not how Vijay Madan Lal Chaudhary should be read. It is read completely, and learned single judge has very rightly read that. I will show, my lord, learned single judges. It's an eminently just judgment. Now see next sentence, my lord. Last sentence of para 272. However, passions aside, we must first balance the law to be able to save the basic tenets of fundamental rights and laws of the country. After all, condemning an innocent man is a bigger misfortune than letting a criminal go. Please say this, my lord. Is ED, my lord, weaponized for the purpose of harassing innocent citizens? And selectively, my lord, learned Judge Justice Nagaprasanna, my lord, another petition was filed by the same petitioner, public spirited. My lord, the day after the judgment came, where section 17A, permission by honorable governor, was, my lord, approved by the High Court. He files a second petition next day saying now transfer it to CBI. That was dismissed by learned single judge, and in that learned single judge records that there are as many as 38 cases pending before Lokayukt court against top politicians of BJP, Congress and Janata Dal for last 30 years, 25 years. One chief minister, former chief minister, is facing 11 inquiries. So you don't proceed against them. ED has nothing to do with them. But ED comes in here. Now that's, my lord, something I respectfully submit. Your lordships is not just a court of law. Your lordships are a court of equity as well. Your lordships are there to protect constitutional rights of citizens. And your lordships therefore would err on the right side of protecting rights rather than allowing a flimsy inquiry and harass innocent citizens. That is what this para says. This is not some drug money. Now see, my lord, kindly turn paragraph 282 straight away. Para 282. Be it noted, now see, my lord, this is where my distinguished friend makes an error that learned single judge has gone overboard. My lord, my learned friend used the expression judgment is perverse more than 17 times in his arguments. I was counting. It is not a perverse judgment. It is an extremely erudite, a good judgment laying down correct law following Supreme Court judgment. Please see now what 282, jurisdiction. Be it noted that the authority of the authorized officer under the 2002 Act to prosecute any person for offense of money laundering gets triggered only if there exists proceeds of crime within the meaning of section 21U of the 2002 Act. Further, it is involved any process or activity, not even in a case of existence of undisclosed income, and irrespective of its volume, the definition of proceeds of crime under section 21U will get attracted unless the property has been derived or obtained as a result of criminal activity relating to a scheduled offense. What if a government takes a policy decision and that decision is implemented for 3 decades by every government? Every authority, my Lord Justice Arvind will inform your lordships that every statutory authority in Karnataka, whether it is Bangalore Development Authority, Shinmoga Authority, every authority has followed this policy of allotment of plots. Are we going to reopen those cases and not condemn people under this act? That, Lord, is something which is a very serious issue. After all, Lord, that's why I said, as Justice Chandrachud very rightly points out in Minerva Bills, Lord, only Articles 14, 19, and 21 stand between that, Lord, dream of Rabindranath Tagore. So, Lord, I suggest your lordships may kindly see what is happening. Now, please see next page, a para 232, 283, sorry, 283. Even though Act is a complete code in itself, it is only in respect of matters connected with offense of money laundering, and for that existence of proceeds of crime within the meaning of section 21U Act is quintessential. Money laundering. Lord, government scheme is not a money laundering scheme. It's a statutory scheme under a statute. Absent existence of proceeds of crime as aforesaid, the authorities under 2002 Act cannot step or initiate prosecution, cannot step in. So this is the jurisdiction, my lord. This is the authority. This is what Ujjambai, Coffee Board, and all those cases have held, my lord, for last 77 years. That if you have no jurisdiction, you can't start an inquiry. And High Court will step in and say that this inquiry must be forthwith stopped and it will be quashed. Series of constitution bench judgments of the Honorable Supreme Court. Now please see, my lord, para 284. In other words, now, my lord, this is on reason to believe. My learned friend made a lot of, my lord, arguments that, oh, single judge is perverse because he says reason to believe. In other words, authority under 2002 Act is to prosecute a person for offense of money laundering only if it has reason to believe, which is required to be recorded in writing, that person is in possession of proceeds of crime. Only if that belief is further supported by tangible and credible evidence indicative of involvement of person concerned in any process or activity connected with proceeds of crime, action under the Act can be taken forward for attachment and confiscation of proceeds of crime, and until vesting thereof in the central government, such process initiated would be a stand-alone process.
These observations in paragraph 284 are more relatable to the stage of section 19 or?
Yeah, but, first part is about 17. Second part is 19. Your lordships are right. First part is reason to believe. You can start inquiring only if that there is a reason to believe. My lord is
Because
right.
the conclusion that the one is in
That is the
possession
second
of
part. Further proceed for attachment. My lord is right, absolutely. Second part is for attachment.
correct.
So, my
Yes.
lord, you cannot enter unless you